force as to any other contracting party when notice of ratification by it has been received by the depository government. Any such contracting party from which no notice of ratification is received within a period of 2 years from the date of entry into force of the modification or amendment in accordance with the provisions of subparagraph 1A of this article shall be deemed to have withdrawn from the present treaty on the date of the expiration of such period. 2A. If after the expiration of 30 years from the date of entry into force of the present treaty, any of the contracting parties whose representatives are entitled to participate in the meetings provided for under Article 9 so requests by communication addressed to the depository government, a conference of all the contracting parties shall be held as soon as practicable to review the operation of the treaty. B. Any modification or amendment to the present treaty which is approved at such a conference by a majority of the contracting parties there represented, including a majority of those whose representatives are entitled to participate in the meetings provided for under Article 9, shall be communicated by the depository government to all the contracting parties immediately after the termination of the conference, and shall enter into force in accordance with the provisions of paragraph 1 of the present article. C. If any such modification or amendment has not entered into force in accordance with the provisions of subparagraph 1A of this article within a period of 2 years after the date of its communication to all the contracting parties, any contracting party may at any time after the expiration of that period give notice to the depository government of its withdrawal from the present treaty, and such withdrawal shall take effect 2 years after the receipt of the notice by the depository government. Article 13. 1. The present treaty shall be subject to ratification by the signatory states. It shall be open for accession by any state which is a member of the United Nations, or by any other state which may be invited to accede to the treaty with the consent of all the contracting parties, whose representatives are entitled to participate in the meetings provided for under Article 9 of the treaty. Ratification of or accession to the present treaty shall be effected by each state in accordance with its constitutional processes. 3. Instruments of ratification and instruments of accession shall be deposited with the government of the United States of America, hereby designated as the depository government. The depository government shall inform all signatory and acceding states of the date of each deposit of any instrument of ratification or accession, and the date of entry into force of the treaty and of any modification or amendment thereto. 5. Upon the deposit of instruments of ratification by all the signatory states, the present treaty shall enter into force for those states and for states which have deposited instruments of accession. Therefore, the treaty shall enter into force for any acceding state upon the deposit of its instrument of accession. 6. The present treaty shall be registered by the depository government pursuant to Article 102 of the Charter of the United Nations. Article 14. The present treaty, done in the English, French, Russian, and Spanish languages, each version being equally authentic, shall be deposited in the archives of the government of the United States of America, which shall transmit duly certified copies thereof to the governments of the signatory and acceding states. In witness thereof, the undersigned plenipotentiaries, duly authorized, have signed the present treaty, done at Washington this 1st day of December, 1959. For Argentina, Adolfo Schillingo, F. Bello. For Australia, Howard Beale. For Belgium, Obert de Theusius. For Chile, Marcial Mora M. L. Gajardo V. Julio Escudero. For the French Republic, Pierre Charpentier. For Japan, Kyoichiro Asaki. T. Shimoda. For New Zealand, G.D.L. White. For Norway, Paul Cote. For the Union of South Africa, Wenzel C. du Plessis. For the Union of Soviet Social Republics, V. Kuznetsov. Romanization. For the United Kingdom of Great Britain and Northern Ireland, Harold Kachia. For the United States of America, Herman Flieger, Paul C. Daniels. I certify that the foregoing is a true copy of the Antarctic Treaty signed at Washington on December 1st, 1959, in the English, French, Russian, and Spanish languages, the signed original of which is deposited in the archives of the government of the United States of America. I, in this context, is the above names. In testimony whereof I, Christian A. Herter, it's the Secretary of this state, Christian A. Herter. In testimony whereof I, Christian A. Herter, Secretary of State of the United States of America, have hereunto caused the seal of the Department of State to be affixed and my name subscribed by the authentication officer of the said department at the city of Washington in the District of Columbia, the 2nd day of December, 1959. And then there's a parenthetical that says seal, Christian A. Herter, Secretary of State, by Barbara Hartman, Authentication Officer, Department of State. There's an additional Part 4. Text of United States Note of May 2nd, 1958. We're going to leave that off. There is one additional part on this manuscript that cuts off, but I'm going to read it just for the sake of completion. Text of United States Note of May 2nd, 1958. Excellency, I have the honor to refer to the splendid example of international cooperation which can now be observed in many parts of the world because of the coordinated efforts of scientists of many countries in seeking a better understanding of geophysical phenomena during the current International Geophysical Year. These coordinated efforts of the scientists of many lands have as their objective a greatly increased knowledge of the planet on which we live and will no doubt contribute directly and indirectly to the welfare of the human race for many generations to come. Among the various portions of the globe where these cooperative scientific endeavors are being carried on with singular success and with a sincere consciousness of the high ideals of mankind to which they are dedicated is the vast and relatively remote continent of Antarctica. The scientific research being conducted in that continent by the cooperative efforts of distinguished scientists from many countries is producing information of practical as well as theoretical value for all mankind. The International Geophysical Year comes to a close at the end of 1958. The need for coordinated scientific research in Antarctica, however, will continue for many more years into the future. Accordingly, it would appear desirable for those countries participating in the Antarctic program of the International Geophysical Year to reach agreement among themselves on a program to assure the continuation of the fruitful scientific cooperation referred to above. Such an arrangement could have the additional advantage of preventing unnecessary and undesirable political rivalries in that continent, the uneconomic expenditure of funds to defend individual national interests, and the recurrent possibility of international misunderstanding. It would appear that if harmonious agreement can be reached among the countries directly concerned in regard to friendly cooperation in Antarctica, there would be advantages not only to those countries but to all other countries as well. The present situation in Antarctica is characterized by diverse legal, political, and administrative concepts which render friendly cooperation difficult in the absence of an understanding among the countries involved. 7 countries have asserted claims of sovereignty to portions of Antarctica, some of which overlap and give rise to occasional frictions. Other countries have a direct interest in that. This particular PDF, of which was copies of said documents, finishes there. Footnote 1. Addressed to this last part 4 was addressed to the foreign ministers of each of the 11 other countries participating in the International Geophysical Year activities in Antarctica: Argentina, Australia, Belgium, Chile, France, Japan, New Zealand, Norway, the Union of South Africa, the USSR, and the United Kingdom. Each note was signed and delivered by the American ambassador to that country. So as we just heard, part 4 was a letter to the other countries. And also, just a few things to recap is that basically this entire treaty was designed and is presided over by the United States. And furthermore, the International Geophysical Year is something that you might have had a question about, and I'm just orating from Wikipedia here. It was an international scientific project that lasted from July 1st, 1957 to December 31st, 1958. It marked the end of a long period during the Cold War when scientific exchange between East and West had been seriously interrupted. 67 countries participated in International Geophysical Year projects. It encompassed 11 earth sciences: aurora and airglow, cosmic rays, geomagnetism, gravity, ionospheric physics, longitude and latitude determinations, precision mapping, meteorology, oceanography, seismology, and solar activity. The timing of the IGY was particularly suited for studying some of these phenomena. Basically another interesting component, just worth noting, was that there is a reference to the Charter of the United Nations as a sort of a guide stone. Right here in Article 3, Part 2, it said, in implementing this article, every encouragement shall be given to the establishment of cooperative working relations with those specialized agencies, capital S, capital A, of the United Nations and other international organizations having a scientific or technical interest in Antarctica. Article 6 deserves particular note. just because it deals with the actual physical location of the sort of the teeth of the treaty. So just read that one more time. The provisions of the present treaty shall apply to the area south of 60 degrees south latitude, including all ice shelves. But nothing in the present treaty shall prejudice or in any way affect the rights, or the exercise of the rights, of any state under international law with regard to the high seas within that area. So, just logically determining what that means, any state under international law, this treaty would not affect their rights to the high seas within that area. So everything south of 60 degrees south latitude, the treaty does not affect the rights of any state under international law. In Article 1, I used the Latin phrase inter alia. That may have been confusing. It means among other things. And so I'll just read that again so that you can hear it and know what it means. Article 1, Part 1. Antarctica shall be used for peaceful purposes only. There shall be prohibited, inter alia, among other things, any measures of a military nature, such as the establishment of military bases and fortifications, the carrying out of military maneuvers, as well as the testing of any type of weapons. Also, the issue of the claims of sovereignty existent prior to the application of the Antarctic Treaty seems to be of relevance. Essentially, the treaty indicated, in my reading and in my estimation, and this is not legal advice, that once you participated in the treaty, it didn't obviate your claims to sovereignty, a particular nation state's claims to sovereignty, pre-existing claims to sovereign territories in the area. It meant that you couldn't enlarge upon them, and also that it seemed to indicate that you would aim towards peace in the sort of Venn diagram when other nations' territorial sovereign claims overlapped with yours. You would sort of aim for peace. That was seemed to be the gist of the relationship between territorial sovereignty in Antarctica. And that was in Article 4, and just as I like to refer to what I'm talking to, I'm just going to read that again real quick because they're so short. Nothing contained in the present treaty shall be interpreted as a renunciation by any contracting party of previously asserted rights of or claims to territorial sovereignty in Antarctica, b. a renunciation or diminution of any contracting party of any basis of claim to territorial sovereignty in Antarctica, which it may have, whether as a result of its activities or those of its nationals in Antarctica or otherwise. C. Prejudicing the position of any contracting party as regards its recognition or non-recognition of any other state's right of or claim or basis of claim to territorial sovereignty in Antarctica. Part 2. No acts or activities taking place while the present treaty is in force shall constitute a basis for asserting, supporting, or denying a claim to territorial sovereignty in Antarctica or create any rights of sovereignty in Antarctica. No new claim or enlargement of an existing claim to territorial sovereignty in Antarctica shall be asserted while the present treaty is in force. Also, a further reference point in Article 13, subsection 6, it says the present treaty shall be registered by the depository government pursuant to Article 102 of the Charter of the United Nations. So, it's registered pursuant to Article 102 of the Charter of the United Nations. So in a subsequent video, I will orate Article 102 of the Charter of the United Nations, and probably the Charter of the United Nations in its entirety, presuming that it's not ridiculously long. One other point of confusion may have been the continued reference to the depository government, and it was referred to throughout all of the articles, many of the articles, and then wasn't actually informed or declared as to what it was until Article 13, subsection 3, which reads, "Instruments of ratification and instruments of accession shall be deposited with the government of the United States of America, hereby designated as the depository government." So the United States of America is what is being referred to in all the other parts of the treaty that mention the depository government. Lastly, I wanted to touch on one other component to Article 6, which says that the provisions of the present treaty shall apply to the area south of 60 degrees south latitude, latitude including all ice shelves, but nothing in the present treaty shall prejudice or in any way affect the rights or the exercise of the rights of any state under international law with regard to the high seas within that area. So I just did a little looking into what is a state under international law, and I came up with something which is an opinion of Dr. Walid Abdulrahim, the professor of law. And this is a section entitled "As a State as a Subject of International Law." I'm just going to read the first couple paragraphs. This is not my legal advice, and I'll leave a link to this particular website, and you can investigate the validity of it for yourself. In general, a subject, a person of law, is an entity to whom the law provides rights and assigns obligations. The requirements to be met for an entity to be considered a subject of international law are the ability to have rights and obligations under international law, the capacity to enter into relations with other subjects, and to stand before international courts. States are, in this sense, clearly subjects of international law since they fulfill all of these requirements. A state is the primary legal subject, person, in international law. A state, by evidencing a separate legal and corporate personality, fulfills the basic requirement for the entrance into the community of nations. For an entity to be a state, it should be free from political control of another state and be free to enter into relations with other states. Section 1, Definition and Requirements of Statehood. There is no exact definition of the term state in international law. However, in this law, the essential criteria for statehood are well settled. Article 1 of the Montevideo Convention on the Rights and Duties of States of 1933 provides the following. The state, as a person of international law, should possess the following qualifications. A permanent population. B, a defined territory. C, government. And D, capacity to enter into relations with other states. According to this article, an entity to be a person of international law, it should fulfill the enumerated qualifications which are regarded as the essential requirements or characteristics of statehood. However, these requirements are not exhaustive. Other requirements may be relevant, including sovereignty, independence, self-determination, and recognition. These requirements are considered in correlation of the essential requirements. All these requirements are considered below. So what is a permanent population? The existence of a permanent population is naturally required as an initial evidence of the existence of a state. This requirement suggests a stable community. Evidentially, it is important since in the absence of the physical basis for an organized community, it will be difficult to establish the existence of a state. The size of the population, however, is not relevant since international law does not specify the minimum number of inhabitants as a requirement of statehood. Nevertheless, an acceptable minimum number of inhabitants is required with regard to self-determination criterion 3. Which we will get to. A defined territory. The requirement of a permanent population is intended to be used in association with that of territory. What is required by a defined territory is that there must be a certain portion of land inhabited by a stable community. A defined territory does not suggest that the territory must be fixed and the boundaries be settled, since these are not essential to the existence of its state, although in fact all modern states are contained within territorial limits or boundaries. The past practice shows that the existence of fully defined boundaries is not required, and that what matters is the existence of an effective political authority having control over a particular portion of land. In 1913, Albania was recognized as a state by a number of states, even though it lacked settled boundaries, and Israel was admitted to the United Nations as a state in spite of disputes over its existence and territorial delineation. The existence of a particular territory over which a political authority operates is essential for the existence of a state. For this reason, the State of Palestine, declared in November 1988 at the Conference of Algiers, was not legally regarded as a valid state since the Palestine Liberation Organization had no control over any part of the territory it was claiming. So you have to be able to control the land you're claiming as your state, but it doesn't have to have fixed boundaries per se. Again, this is not legal advice. The size of the territory of the state and alterations to its extent, whether by increase or decrease, do not of themselves change the identity of that state. A state continues to exist as long as a portion of land is retained. C, a government. For a stable community to function reasonably effectively, it needs some sort of political organization. It is required that an effective government be created, and this political authority must be strong enough to assert itself throughout the territory of the state without foreign assistance. The existence of an effective government with some sort of centralized administrative and legislative organs assures the internal stability of the state and its ability to fulfill its internal obligations. However, the requirement related to the existence of an effective government having control throughout its territory, although strictly applied in the past practice, it has been subjected to certain modification in modern practice. In certain cases, the requirement of an effective government was not regarded as precondition for recognition as an independent state. The state of Croatia and the state of Bosnia and Herzegovina were recognized as independent states by the member states of the European Community and admitted to membership of the United Nations at a time when substantial areas of the territories of each of them, because of civil war, were outside the control of each government. In other cases, the requirement of an organized government was unnecessary or insufficient to support statehood. Some states had arisen before government was very well organized, as for example Burundi and Rwanda, which were admitted as states to the membership of the United Nations in 1961. Moreover, a state does not cease to exist when it is temporarily deprived of an effective government because of civil war or similar upheavals. The long period of de facto partition of Lebanon did not hamper its continuance as a state. The lack of a government in Somalia did not abolish the international personality of the country. Even when all the territory of a state is occupied by the enemy in wartime, it continues to exist, as in the cases of the occupation of European states by Germany in the Second World War and the occupation of Germany and Japan by the Allied powers after that war. Nevertheless, the requirement of effective government remains strictly applied in case when part of the population of a state tries to break away to form a new state. D. A capacity to enter into relations with other nations. The capacity to enter into relations with other states is an attribute of the existence of an international legal personality. A state must have recognized capacity to maintain external relations with other states. Such capacity is essential for a sovereign state. Lack of such capacity will avert the entity from being an independent state. Capacity distinguishes states from lesser entities such as members of federation or protectorates, which do not manage their own foreign affairs and are not recognized by other states as full members of the international community. Other requirements: independence, sovereignty, self-determination, and recognition are other requirements of statehood, used either as separate criteria or in association with the above requirements. The concept of independence means that the state is subject to no other state. Many jurists stress on independence as the decisive criterion of statehood. Some consider independence the essence of a capacity to enter into relations with other states and represented by this capacity. Others consider it in association with requirement of effective government. To them, if an entity has its own executive and other organs and conducts its foreign relations through its own organs, then it is independent, and this is a prima facie evidence of statehood. Some jurists consider sovereignty as an important criterion of statehood. Even some of them use the term sovereignty as a synonym for independence. The concept of sovereignty denotes internally the supreme undivided authority possessed by a state to enact and enforce its law with respect to all persons, property, and events within its borders, and externally the capacity of a state to enter into relations with other states, such as sending and receiving diplomats and engaging in treaty making, and the enjoyment of certain immunities and privileges from the jurisdiction of other states. Sovereignty in this regard is the indication of the international personality of an entity seeking a status of state in the community of nations. Lack of sovereignty suggests that an entity is not independent and has no international legal personality, and consequently not a state. However, some others reject sovereignty as a criterion of statehood on the considerations that Germany, after 1945, although lost considerable extent of its sovereignty, continued to exist as a state. In the practice of states, the principle of self-determination has been used as a criterion modifying the requirement of effective government. The evolution of the right of self-determination has affected the level of effectiveness a concerned government required to exercise in order to fulfill such requirement of statehood. Therefore, the evolution of the right of self-determination has affected the level of effectiveness a concerned government required to exercise in order to fulfill such requirement of statehood. Therefore, a lower level of effectiveness has been accepted. This occurred particularly in decolonization situations where colonies were seeking their independence and the creation of their states. Moreover, the principle of self-determination has been used as an additional criterion of statehood in certain circumstances, such as in the case of Rhodesia, when it unilaterally declared its independence on November 11, 1965, and in the cases of the successor states of the former Yugoslavia. This additional criteria may be required in the future in cases of certain national minorities seeking independence and the creation of their states. In the context of the constitutive theory of recognition, recognition has been required as an additional criterion of statehood. The constitutive theory considers that the act of recognition constitutes or creates the new state. The existence of a state begins with its recognition by other states. Accordingly, it is only through recognition that a state comes into being under international law. The practice of states has required recognition as an additional criterion of statehood in certain instances, such as in the case of Rhodesia in 1965. At that time, although Rhodesia might have been regarded as a state by virtue of satisfaction of all the requirements of statehood, the factual requirements, enumerated in the Montevideo Convention of 1933, its status as a state was denied because no state did recognize it. So in a future video, we may also read whatever is available about the Montevideo Convention of 1933. So just to round that up in short, a state under international law does not have a definitively defined definition. However, it's generally considered to be something with a permanent population, a defined territory, a government, and the capacity to enter into relations with other states. Possibly the last of them being the most significant. Recognition by other states as a state may, to some jurists, be a final determination of the capacity for statehood. All of that was to say who or what could consider themselves a state if venturing past the 60th degree of south latitude into Antarctica under international law without breaking or being in dishonor toward the articles of the Antarctic Treaty, in particular Article 6. The provisions of the present treaty shall apply to the area south of 60 degrees south latitude, including all ice shelves, but nothing in the present treaty shall prejudice or in any way affect the rights or the exercise of the rights of any state under international law with regard to the high seas within that area. In other words, they can't lay claim to the water. All right, you've been listening to Spiritual North. Thanks for tuning in. This channel is for research and investigation purposes. If you enjoy my music, follow the link below to my new channel, Frank America. God bless.